Hello and welcome to Legally Speaking with me Tarun Nangia. Today we begin our part 2 of the Justice H.R. Khanna Memorial Lecture Series, which this year in 2018 Senior Advocate Siddharth Luthra, he gave an address at the Justice H.R. Khanna Memorial Lecture and made very strong points related to how there is an increasing tendency in the legislature, executive and the police for expanding its powers, which are now curtailing personal liberty and is actually affecting democracy as a whole, because when there is a presumption of guilt, the moment a person is charged, then you are turning India into a country where we have very different notions about justice, and how will that affect our democracy? To understand all these issues from here in perspective with the laws made in under the IT Act, the NDPS, which is the Narcotic Drugs and Psychotropic Substances Act, also TADA, POTA, and so many other laws, be it the dowry prohibition law. We'll discuss all that and more with Mr. Luthra. Mr. Luthra, very strong points from you in the Justice H.R. Khanna Memorial Lecture. You seem to be pretty, actually not happy with the way things are going.
You know, the one thing I didn't speak about in that lecture was victims' rights and victimology, because that was not the focus of my lecture. I must clarify that over the last 15-20 years, there has been a serious concern for victims' rights. It's been recognized in the 2010 Constitution Bench decision. Victims now have a right to appeal under the amendment to Section 372, and that's part of the system. So while victims who did not have a great participation have been allowed to participate in the process in a much larger way, the fact that there are victims' rights should not be used to dovetail or restrict the rights of the accused, which are protected under the CRPC. And it's not a trade-off between either or. Okay. Both have to be balanced. Secondly, what I want to say is, I think the victim has the right to a fair and free investigation and trial. And a victim's concerns and a victim's cause is definitely relevant at the sentencing stage. But then we also need to consider, what kind of society do we want? A society based on retribution, a society based on deterrence, or a society based on rehabilitation? I believe that today there is no clarity as to which of these three parameters we want. I have serious concerns about how, over the last few decades, we have curtailed the procedural safeguards. One of the concerns I have is that harsher laws, graver punishments, reversing the burden both at the stage of bail, in the terrorist laws, in organized crime, in NDPS, and therefore ensuring that there's pre-trial detention, which is really punitive and not preventive, and without any legal justification. All of this has led to an approach, and all these laws have been upheld. Wherever challenged, they've been upheld by the courts. It's led to a view that the governments of the day can bring in harsher legislations, and implicit in that is an understanding of the governments that these are likely to pass muster with courts. That's a very scary and serious thought. The second part is, consistently to meet situations of what they treat as aberrant or deficient investigations and deficient prosecutions, the courts have diluted procedural standards of recovery of evidence, of sources of evidence, and these are legislated standards. Why have the courts been able to do it? There is in the CRPC, which is our fundamental procedural law, Chapter 35 in the 73 Code and Chapter 45 in the old code. They are almost parametric, almost similar. Now, Chapter 45 dealt with irregular proceedings, as does Chapter 35 of the new code, and says, by and large, that barring about 10 classes of acts, procedural defects, which can lead to vitiation of the proceedings, all others have to be tested on the anvil of irregularities, failure of justice, and that there should be prejudice to the accused. Now, this is very interesting, because here the burden is on the accused to show that prejudice has been caused and that there's a failure of justice. So on the one hand, you set up the entire body of the CRPC which deals with procedural fairness. On the other hand, you have this irregularity chapter which was all very well prior to the Constitution. The moment you have 1950, you have the Constitution. This should have been diluted or modified. But when the Law Commission looked at this in 1969, in the 41st report of the Law Commission, I find there is no mention in the chapter on irregular proceedings of Article 21 of procedure established by law. So there is no mention. And the same chapter is reenacted in the 73 Code. And that is used sometimes specifically, sometimes otherwise, to dilute procedural safeguards.
Okay.
That it's an irregularity, not an illegality.
Now, going on ahead with the address that you gave, you spoke about the TADA Act, which lasted till 1995, permitting use of police confessions, and which in fact, if you have mentioned it, that must have really troubled you, that we were even at a stage when police confessions were admissible under the guise that there are crimes in which that's the only way that police can extract a confession, by beating or other extraneous methods.
There are other provisions also which are similar, and I'll tell you what troubles me more is, in 1997, the Supreme Court came out a decision which is called State through CBI versus Anil Sharma. I think this was part of those telecom or some scams of the time. Now, what happened in this judgment? The anticipatory bail had been granted to the accused. The Supreme Court quashed the anticipatory bail order, holding that a person who has an anticipatory bail order will not answer an investigation and therefore justifying custodial interrogation. Implicit in that decision is the right of the prosecution to use, or rather the right of the investigators to use third-degree methods. Very scary decision. It remains to the law of the day. And that provision, since it justifies custodial torture, tells you of the mindset. Now, I do understand that courts have to deal with hard situations. People get orders which are not perhaps legally sustainable, but then quash the order. This kind of sentence leads to a shockwave around the courts in the country, and every individual's rights under Article 21 are going to get restricted, and have got restricted. And these are concerns that I have to meet. So you'll find that from the 1980s, you had the Constitution Bench decision in Gurbakh Singh Sibhi, anticipatory bail, very high standard put, liberty is important. They explained it. After that, you've had successive dilutions till 2011, and only in 2011, in Maitre's case, there's a balance against pre-trial detention made in Maitre's case, which is again under reconsideration by the court. Now, this kind of permission by the court of dilution of procedural standards and harshness in terms of and restriction of the 21 rights causes me great anguish.
Okay. Now, and you also spoke about the defamation bill which had to be withdrawn. You highlighted, since you spoke of the 80s, you spoke of making the Negotiable Instrument Act a criminal offence. You also highlighted the in the 1990s, the stock exchange scam, the draconian laws of FERA and FEMA. Now, if you go by the attitude of the political class, which in the end gives some kind of legitimacy to these kind of laws, do you see the judiciary now reacting in a positive way? I'll tell you how. Justice Rohinton Nariman recently, authored a judgment where he held the Section 45 of the PMLA Act unconstitutional, saying that you cannot take away personal liberty. And do you think judiciary is now sensitive, or maybe slowly things will start to change?
I think there are two judgments of Justice Nariman. One is the Shreya Singhal, where 66A of the IT Act was quashed. The second is the decision which you've just mentioned in the PMLA case, Nikesh Tarajan Shah, if I'm not mistaken. Yes. These are very important decisions. But even in Nikesh, the court leaves the window open for laws where state's security is at stake. And there, they say there is that they really bring the PMLA laws at a step lower and say where there's a state security, harsh restrictions on bail may be justified. Which means, in essence, that while quashment of PMLA bail restrictions, the court is permissive and has to be because of Kartar Singh's case on the restrictions of bail in terrorist acts which are now under the Unlawful Activities Prevention Act. So we have to see that the courts have acted, but till Kartar Singh's case goes or is diluted, I don't see enough of a change. In fact, I believe that the quashment, take for example the quashment of gay sex, 377, yes. The quashment of provision prescribing gay sex. 1860 you have a law. It's a law which is really comes from Christian religious law, ecclesiastical law. You bring it into India, you see the Law Commission reports of the 1830s, and that it makes it clear what its origins are. And you took how many years to quash it? 158 years to quash that. Now these are concerns. I think it's not the courts will quash the law if an issue comes before them. But why are the governments of the day not willing to scrutinize the efficacy and the rationale behind the continuance of these laws? And if they are not efficacious, and if they are not meeting the legislative purpose, and if they are just creating unduly strong powers within the police, then these laws need to be looked at and perhaps need to go as well and as soon as possible.
That brings me to your speech where you also spoke about the increased, the Information Technology Act in 2000, which provided for criminal liability. For the Section 66A, there was a huge hue and cry where, arrests were being made rampantly for some offhand comment made on social media. Your views on that law, and what kind of progress do you see that has been made and what needs to be made?
I must tell you, I had appeared at one stage on behalf of the government in that litigation, and at that stage I'd made a statement which became a great safeguard. I was told later that no arrest can be carried out till the DCP, the Deputy Commissioner of Police, or the SP authorizes an arrest.
Okay.
So I was told that helped at some point of time, but as I said, that was in my capacity as a law officer.
Yes.
I think striking down of 66A on the ground of arbitrariness, of loose language, was important. But then we are looking at 3 or 4 stray instances in the last
10 years or so.
Many years.
10, 15 years.
Why don't we look at the number of cases where the legislations have been upheld? A. Why don't we also look, for example, the challenge to organized crime was upheld. Why don't we also start looking seriously at the reverse burden and how it has been upheld, the presumption has been upheld in Noor Agha's case in 2008.
Okay.
So, my concern is a few instances of action by the courts is not enough. And eventually, as I said, the courts will only test what comes before them.
Yes, it comes up to the Supreme Court.
If it comes to the Supreme Court and if it's challenged. But if it's not going to be challenged, if it's not going to come to the Supreme Court, then that's a concern. Secondly, I think it's also time, realizing the nature of harshness of sentencing that is now coming about in the last few years and the reverse burden, there needs to be a serious relook by the courts whether the dilution of standards, procedural standards in the CRPC and other procedural laws need to be looked at. And again, we need to revert back to the position in the legislation as it existed.
Now, there is an issue which also got a lot of publicity recently in the media, which speaks about enhanced corporate criminal liability. If I may highlight an example, the promoter of Bhushan Steel was put behind bars very recently, and that raised, that was not taken well by corporate India. Some joke that the man lost his company and now ends up in jail. If you may take that example a bit ahead, what kind of message are we sending to corporate India with such laws?
Okay. I must confess I've appeared for the gentleman. I don't like speaking on cases that I've appeared in. I represented him. We filed a petition challenging the provisions. The High Court released us on bail. The state challenged it in the Supreme Court. When the challenge was there in the Supreme Court stayed the operation of the judgment of the High Court, and today the matter is pending in the Supreme Court, but our client is out on bail. I have a fundamental concern. Can we, A, justify legally a reverse burden on bail in a company's laws offense? It's an offense of fraud. It is akin to breach of trust, cheating maybe, assuming for a moment, and I don't think, at the highest it may be a case of forgery. All these provisions are in the IPC.
Yes.
None of them have a reverse burden.
Yes.
then how can you justify a reverse burden under 447? That's question number one. The second issue is, isn't 447 of the Companies Act surplusage? Now, by no means should we allow a breach of the law to be continued, but merely because the Indian state is not efficient enough in prosecuting those who ought to be prosecuted or preventing offences is no ground to add harsher laws.
Okay. Okay. That's a fair point there, and at this juncture we take a short break and be right back. Welcome back. Just before the break, we had Senior Advocate Siddharth Luthra explaining to us on corporate criminal liability and other allied issues. We'll take this discussion ahead, and he also spoke about the court's powers to strike down laws made by legislature where they feel that it may hurt personal liberty on all or other issues. But I will read out this quote which he quoted in his speech. He's quoted Mr. K. Munshi, who spoke on due process, while Dr. B.R. Ambedkar expressed his difficulty with Mr. Munshi's due process amendment and explained it as giving the judiciary the power to question the law made by legislature on another ground. That ground would be whether that law is in keeping with certain fundamental principles relating with the rights of the individual. In other words, now this is important, judiciary would be endowed with the authority to question the law not merely on ground whether it was in excess of the authority of the legislature, but also on the ground whether the law was good law. Please explain to us why you chose to make this part of your speech.
When the Constitution was debated in the Constituent Assembly, there was a view by certain luminaries of the time, Mr. Munshi and others, that there should be an amendment to draft Article 15, which became Article 21, and we should use the phrase due process and not procedure established by law. Procedure established by law was, a due process was there in the American Constitution. People like Mr. Munshi mooted it. Dr. Ambedkar explains due process just below that in my talk, but declines to support the amendment, and the amendments were not passed. In essence, due process did not become a part of our Constitution. Subsequently, we had the Keshwanand Bharati case where basic structure doctrine was propounded. And I would say that thereafter we have Maneka Gandhi, where this concept of testing a law on the anvil of various fundamental rights and the interrelation between fundamental rights is really another way of introducing due process. Therefore, what Mr. Munshi wanted is today, according to me, essentially partly achieved, though by judicial interpretation. And that's important, because when we look at Justice Khanna's dissent, which we now believe in increasingly, that laws should not only be tested on the legislative entries and whether they conform to it or not, whether the government has power to make laws, but that A, they must not interfere with the basic structure of the Constitution, it must not interfere with the fundamental rights, they must not interfere with the rule of law. Now, if these parameters have to be seen, I think we've evolved a lot from the time that desire to put in due process was negatived.
Okay.
And that is a very important development in Indian law.
Okay, and because you quoted Mr. Munshi, and you also quote in your speech that he raised a concern even then that there is a tendency to pass legislation in a hurry which gives sweeping powers to the executive and the police, which means it was a worry even 70 years ago.
Let's go back to that time.
Yes.
You and I weren't born then, yes, but let's try and place ourselves in the mind of our freedom fighters,
yes,
who had fought the colonial masters,
yes,
who had seen harsh laws being brought in, were giving sweeping police powers.
Yes.
They were great judges of human character.
Okay.
They were conscious of the fact that in the future, we may not have colonial rulers, but people within our own polity may be willing and have a tendency to bring in such harsh laws. So they had a desire to protect the citizenry of this country from a time of absolutism. And that is the reason they raised this concern. This concern gets raised again by Justice Khanna in 1976 in the habeas corpus case in his dissent. And it is a concern which continues to be there.
And it's a concern which you propounded in your speech that day.
I must be very candid. I am seriously concerned about how we've had, as I said, over the last 5 decades, a number of harsh laws. In some occasions, like the Defamation Bill of 1988, the government, though it was passed to the Lok Sabha, woke up and withdrew it. But at the same time, there have been so many legislations which have gone through.
Okay. You also spoke about Lita Kumari versus State of Uttar Pradesh, which had carved out an exception for mandating preliminary inquiry in cases where there is an abnormal delay and latches in initiating criminal prosecution, and held as to what type of cases preliminary inquiry is to be conducted. And you highlight and you say that it's matrimonial and family disputes, commercial offences, medical negligence cases, corruption cases, cases where there is abnormal delay, latches in initiating criminal prosecution, for example, over 3 months delay. You chose to highlight this. Could you explain why?
Lita Kumari was very important because it was looking at the provisions of registration of FIR section 154, which requires mandatory registration of FIR, yet relying on the various police rules and prior precedents, certain classes of cases were made eligible for an inquiry before an FIR is registered. And that's a very important move in the law. Otherwise, there will be multiple FIRs, and FIRs means the likelihood of arrest, custody, detention, and prosecution, even though it may not be justified. So Lita Kumari was a seminal moment in the decision making by the Supreme Court. It's a Constitution Bench decision. Today, to our surprise and horror, the Supreme Court in the 2018 amendment to the Scheduled Caste Act has really said that any judgment which allows that this preliminary inquiry cannot be done in such cases, and any judgment which says anticipatory bail may be granted will not. In essence, the Supreme Court has tried to overrule the legislature has tried to overrule judgments of the Supreme Court and a Constitution bench. My question is it justified? What changed between 2014 to 2018 on the ground in terms of administratively reviewed facts to justify a removal of the preliminary inquiry, not provision, but removal of the preliminary inquiry option from scheduled caste offences, let's say it's belated by 5 years.
So why you just want to go for arrest right away in everything?
Because in the Scheduled Caste Act, since there is no anticipatory bail, you have to be put to custody.
Yes.
So therefore, you do away with preliminary inquiry, you don't have an anticipatory bail. Despite our glorious judgments in Joginder Kumar and D.K. Basu, the police are more than often not likely to arrest. Where they don't arrest, the media gets after them. You'll get after them and say, please arrest.
Yes.
It may not be Tarun Nangia, but there are enough people from your community, and you'll have candlelight marches. And if you have that, then the police act hastily, and when they act hastily, then people's liberty is lost.
Okay.
So I think the dilution of Lita Kumari by the 2018 amendment is not constitutionally justified, it's not legitimate, it's a knee-jerk reaction to a public outroar at the relevant time.
And how well you quoted from Justice Krishna Iyer, where you said that, quoting him, that freedom of individual is as necessary for the survival of the society as it is for egoistic purposes of the individual. So you also say, quoting him, that it's not about the individual, it is about the democracy and the society at large. In your concluding comments, would you like to say that these two lines we have not understood as a society? That it's not about the individual who may appear to be a crook or a criminal without being prosecuted or the judgment coming out, but it's about the society.
When we made presumption of innocence, which we took from English law, the fundamental essence of our criminal process then hasty arrests, incarceration are abhorrent to that. Yet it happens, and Justice Krishna Iyer made it very clear that for a free, for a fair society, for a society governed by the principle of rule of law, you cannot deprive people of their custody. It must be bail and not jail.
Thank you so much, Mr. Luthra, for sparing your time and sharing us all the things that you said in the Justice H.R. Khanna Memorial Lecture. Thank you so much.